The Department of the Environment has released the most progressive wildlife protection law ever drafted in South Africa. It seemed like good news for the beleaguered wildlife. But just before it became law, game breeder and hunter organizations demanded an immediate ban to stop it. The DFFE responded with a plea, convincingly defended its law, making clear that it strongly opposed the application on the grounds was not particularly urgent. However, at last minute, Department, in a confidential, out-of-court agreement, withdrew norms and standards changes to proposed threatened or protected species regulations and agreed to pay applicants legal costs. Due to urgent timelines of case, Department requested additional time to consider various issues raised in court application by Wildlife Ranching South Africa and Professional Hunters Association of South Africa. So was it urgent or not? One wonders exactly what happened between March 24th, when Ministry presented its comprehensive and well-argued 91-page statement against the ban, and March 27th, when it completely backed out in agreeing to withdraw regulations without explaining any of its arguments. As TOPS regulations are closely linked to other 4 government communiqués, which will also come into effect on April 1st, DFFE has also withdrawn revised norms and standards for management of elephants, leopard hunting and modified conservation list of 266 wild animals. New regulations involving the trade in mammals, fish, birds, invertebrates and plants, and rhino horn. What were the seemingly convincing arguments put forward by WRSAPHASA that caused DFFE to back off? What other agreements or directions have been reached for resolution? And why and on what basis did DFFE agree to pay the costs when, in such cases, both parties normally pay costs? No one is speaking at this stage, and a request made by Our Burning Planet to the DFFE has not received a response. Consultation timeframes. The TOPS regulations were released on February 3rd, before they were made public, at which point WRSA and PHASA met with the department. Were their concerns expressed at the time? What prompted them to take the ministry to court? Explaining challenge faced by court, PHASA CEO Dries van Coller said that TOPS regulations and publication of species lists surprised industry because previous very limited public engagement process was in 2015, 8 years ago. The version of regulation released by Minister differed significantly from previous versions and contained multiple provisions that would undermine the ability of game farmers and professional hunters to do sustainable business in game industry. Van Coller had grounds for complaint. Very limited public participation followed the publication of the TOPS regulations. This contrasts with extensive consultation that followed recommendations of high-level panel on lions, rhinos, elephants and leopards, as well as white paper on biodiversity that has just been approved by Cabinet. It is also surprising that Minister's legal counsel did not take into account the precedent that was approved for public participation requirements in other 2 cases. One was a temporary ban given to Humane Society International-Africa that challenged hunting and export quotas for elephants, rhinos and leopards. The second decision was by Endangered Wildlife Trust, which overturned the Department of Agriculture's inclusion of various wild animal species under Animal Improvement Act. More than time zones, however, reading the TOPS regulations makes it clear why game farmers and hunters press the panic button. It's not just about advisory timeframes. Following high-level panel report, DFFE's cabinet-approved recommendations Animal Welfare, recently published white paper on biodiversity, it is clear that Creecy is sensitive to growing reports and studies of cruelty game farms, particularly lion hunting. Bred for bullets. All this negatively impacts South Africa's abroad at a time when the country desperately needs to rebuild its tourism industry after the COVID pandemic. The new TOPS regulations tighten the thumbscrews on sloppy, inappropriate, dangerous and brutal game farming and hunting in an industry that often takes great pains to fly under the radar. There are significantly tightening regulations on captive breeding, rehabilitation, temporary holding and trade show facilities, game farms and animal translocators. But regulations go even further, listing 266 species as sensitive, endangered, or critically endangered, giving a precise list of restricted or prohibited activities for each. These include all rhino species, elephants, lions, leopards, African wild dogs, cheetahs, hyenas, a range of lowland game, including southern roan and sable antelope, both zebra species. TOPS is also tightening regulations on hunting permits and scrutinizing captive breeding, which should have infuriated breeders and could be the main point of contention in court cases. A major point of contention with so-called canning-related facilities, where hand-reared lions are released for, would be regulations banning the hunting of a large predator in an area adjacent to a captive holding facility. There will also be a ban on bringing wild-caught hunters breeding facilities, a time limit during which rehabilitation facilities will have to return animals the wild, and ban on breeding in sanctuaries. TOPS regulations put picture under the microscope with ability to shut down captive breeding facilities for not following strict guidelines. All animals, the conditions in which they are kept should be documented for official review, and pedigree books should be kept to prevent inbreeding crossbreeding. Enclosures will need to comply with regulations, detailed food supplies for captive animals, plans for waste disposal, and the availability of veterinary services. Captive breeding facilities would need to provide a description of the strategies used in breeding that contribute to maintaining wild populations, a requirement that lion farms would find impossible. Breeding facilities will be denied registration if their activities conflict with anything under the Biodiversity Act or TOPS regulations. Adding to uncertainty, game breeders, their registration can be revoked in the event of a change in conservation status, species bred, raised, propagated, traded, or kept by a permit holder. One weakness of TOPS regulations, this would have been pointed out in court case, is that the tight control required by the DFFE requires far more trained officers and a data collection system that can respond quickly, efficiently. Unfortunately, neither national nor regional environmental departments have any of these. This point was emphasized by Dries and Coller of PHASA. The inability of various national and provincial organizations to manage numerous landscaping is already holding us back. We receive complaints from members about unused leave almost daily. Some states do not have the money to cover the costs associated with legal surveillance jobs. The system stalls because the department does not have enough people and money to do its job. Now we see a minister willing to impose even more conditions on an already over-regulated industry. Here is the question. Will TOPS regulations and associated wildlife laws be shelved, rewritten, or embarked on a new round of competition? No time frame or way forward has yet been proposed. For now, the issue lies in a smoldering fire of confusion. OBP.